The Supreme Court just issued a 9-0 ruling in Barnes v. Felix, and every single gun owner in America needs to hear about it right now. Not tomorrow, not next week, right now. Because this decision didn't just change one constitutional right, it changed two of them at the same time. The Second Amendment and the Fourth Amendment, both of them, simultaneously, in a single ruling. And here's what's terrifying. Most gun owners are still carrying, still driving, still going about their daily lives with absolutely no idea that the rules just changed in a massive and fundamental way. The way police are legally permitted to interact with you during a traffic stop, specifically when you have a firearm in that vehicle, is fundamentally different today than it was before this ruling came down. And whether this ruling protects you or leaves you exposed depends entirely on whether you know about it before you ever see those blue lights in your rearview mirror. Now let me just pause on something before we go any further. 9 justices, 0 dissents. In today's court, a 9-0 decision is almost unheard of. You have justices who disagree on virtually everything, and I mean everything, standing completely unified behind a single ruling. When that happens, you pay attention, because that level of agreement tells you the legal reasoning behind this decision is ironclad. It is not going away. It is not getting reversed by the next administration or the next court. This is settled law. And when a unanimous court speaks, every police department, every lower court, every prosecutor in this country gets the same message at the same time. There is no ambiguity. There is no backdoor. This is the law of the land. So what was the case actually about, and why does it matter so much to you as a gun owner? Here is the core situation. Ashton Barnes was pulled over for an unpaid toll violation, a minor traffic issue. During that stop, officers became aware that there was a firearm in the vehicle. The stop escalated rapidly, and ultimately a shooting occurred. But the legal fallout from that case, the Supreme Court's ruling on how that entire interaction should be reviewed, created a seismic shift in the rules that govern every single traffic stop in America where a firearm is present. The court struck down something called the moment of threat doctrine. And if you don't know what that doctrine is, you need to understand it right now, because it has been quietly working against you for years without most gun owners ever realizing it. Here's what the moment of threat doctrine was. Under this legal framework, which was especially dominant in the Fifth Circuit, covering Texas, Louisiana, and Mississippi, courts were permitted to evaluate police conduct by looking only at the final 2 seconds of an interaction. Literally 2 seconds, not the 5 minutes before, not the 3 minutes of calm, cooperative behavior, not the full context of what happened during the entire stop, just the single moment when tension peaked, the moment an officer felt threatened. Think about what that allowed. An officer could pull you over for something completely minor. A broken tail light, an expired registration sticker, an unpaid toll. You could sit there cooperative and calm for 4 straight minutes. You could follow every single instruction. And then, if the officer chose to escalate, chose to draw a weapon, or jump onto your running board, or create a chaotic situation through their own actions, and you reacted naturally in that chaos, the courts would look only at your reaction in those final 2 seconds. They were legally permitted to put on what Justice Elena Kagan called chronological blinders. They could ignore everything that came before. And whatever they found in that narrow, decontextualized window became the basis for justifying a full vehicle search, use of force, or worse. For gun owners specifically, this was a trap. Because if an officer knew there was a firearm in your vehicle, even a perfectly legal one, they could engineer tension, point to the resulting moment as justification, and the courts would back them up. The chronological blinders made it nearly impossible to challenge. The Supreme Court just threw that doctrine into the trash. All 9 justices agreed. They ruled that courts must evaluate police conduct using the totality of the circumstances across a lengthier time frame. No more blinders. No more 2-second windows of selective review. The entire interaction matters. Your 5 minutes of calm behavior matters. The severity of the original traffic violation matters. Your level of cooperation matters. The reason you were stopped in the first place matters. All of it goes on the record now. All of it gets weighed. And here is why this is just as much a Second Amendment victory as it is a Fourth Amendment one. For years, quietly, one traffic stop at a time, something deeply wrong was happening across this country. Police departments in certain jurisdictions had started treating lawful gun ownership as though it were evidence of suspicious behavior. You get your concealed carry permit, you pass the background check, you pay your fees, you complete whatever training your state requires, you do everything right. You are, by definition, one of the most legally verified individuals on the road. And then you get pulled over for a broken tail light, you inform the officer you're carrying as your state law requires, and suddenly the fact that you are exercising a constitutional right becomes the justification for a complete search of your glove box, your center console, your trunk, your bags, no warrant, no specific evidence of criminal activity, no concrete articulable reason to believe anything illegal was happening, just there is a gun in this car, so we're going to search it. That was happening regularly, and it was wrong the entire time. The Fourth Amendment protects you from unreasonable searches and seizures. In most situations, police need a warrant signed by a judge based on probable cause to search your property, including your vehicle. There are exceptions, always have been. If an officer has probable cause, specific, real, articulable reasons to believe that a crime is being committed or that evidence of a crime is present, they can conduct a search without a warrant in certain circumstances. If there is something illegal in plain view, that is probable cause. If they detect something illegal, that can contribute to probable cause. Context can build toward probable cause, but here is what is not probable cause. And this is exactly what the Supreme Court confirmed in the Barnes ruling and its implications for vehicle stops. The fact that you legally own a gun is not probable cause. The fact that you informed an officer you are carrying, as required by your state law, is not probable cause. The fact that your hands were trembling slightly during the stop is not probable cause. The fact that you drove through a neighborhood where gun crimes have occurred is not probable cause. The fact that an officer feels generally uneasy because a firearm is present is not probable cause. None of those things, alone or in combination, gives an officer the legal right to conduct a warrantless search of your vehicle. And because the Barnes ruling now requires courts to look at the totality of the circumstances, an officer can no longer manufacture a 2-second justification after 5 minutes of calm, cooperative, law-abiding behavior on your part. There is a phrase you need to memorize right now: specific, articulable facts. That is the standard, not a hunch, not a general feeling, not officer discomfort with a legal firearm. Specific, articulable facts that point to actual criminal activity. If an officer cannot point to concrete, explainable, specific reasons beyond your lawful possession of a legally owned firearm, they do not have the grounds to search your vehicle under this ruling, period. Now let's get into what this actually means when you are sitting in your car with a firearm and you see those lights come on behind you. Because knowing your rights theoretically and knowing how to exercise them in real time are two completely different things. And if you do not know the practical mechanics of this ruling, it will not protect you. The first thing you need to understand is that your notification does not become their permission. If you live in a state that requires you to inform an officer that you are carrying a firearm, you still have to do that. This ruling changes nothing about state notification laws. You inform the officer, you do it calmly and clearly. But that notification is not a search warrant. The moment those words leave your mouth, you have not opened a legal door to your entire vehicle. The officer may ask you to step out of the car. Courts have generally permitted that as a reasonable officer safety measure. They may ask to temporarily secure the weapon during the stop. That is different from a full vehicle search. Your trunk is not theirs to search because you told them you are legally carrying. Your bags are not theirs to search. Your center console is not theirs to go through, not without specific, articulable facts that go beyond your legal ownership of a firearm. The second thing to understand is that your carry permit is proof you are following the law, not an invitation to be treated like a suspect. This matters especially for concealed carry permit holders. Your permit represents verified legal authorization. It means you went through a background check. You completed your state's required training. You paid your fees. You are, by definition, one of the most legally screened gun carriers on the road. Some officers have historically treated that permit as though it opens a door to additional scrutiny, as though the very act of going through the legal process of getting permitted makes you somehow more suspicious. The Barnes ruling reinforces the opposite principle. Your permit is evidence that you are operating within the law. It should function as a layer of protection, not as a trigger for suspicion. Under the totality of the circumstances standard, your permit strengthens your position in any legal challenge because it documents your compliance, not your threat. The third thing is something almost no coverage of this ruling is talking about, and it applies even in states where you are not legally required to inform the officer that you are armed. In several states, there is no duty to inform requirement, but officers in some jurisdictions were using their own suspicion, not knowledge, suspicion, that you might have a weapon as justification for a search. I think you might have a gun in this car. Let me check. The totality of the circumstances standard addresses that directly. A generalized suspicion that a driver might be carrying a firearm with no other concrete supporting factors does not rise to the level of specific articulable facts. It never legally did. But now the highest court in the country has drawn that line so clearly that no lower court can credibly ignore it. Here is where I need you to pay very close attention, because this is the part most people are going to miss entirely. There is a back door in this ruling, and law enforcement agencies are already being trained to use it. Since the Barnes decision makes it significantly harder to use your legal firearm as automatic justification for a warrantless search, many departments are pivoting toward consent-based policing. They are going to try to get you to voluntarily give up the very rights this ruling just secured for you. You need to know exactly how that sounds so you recognize it in the moment. It might sound like this. You seem like a law-abiding guy. Since you've got a firearm in there, you wouldn't mind if I just did a quick check to make sure everything's okay, right? It'll get you on your way faster. Or this. I just want to verify the serial numbers to document that we're all safe here. You don't have anything to hide, right? Do not say yes. Do not say I guess so. Do not say go ahead. The moment you give verbal consent, the entire protection that Barnes established disappears. You have legally invited them in, and any evidence they find, even something completely unrelated to your firearm, becomes fair game in court. The consent waiver overrides the constitutional protection. That is the back door, and the only way to close it is to know it exists before you are sitting on the side of the road with an officer looking through your window. The 5 words you need to know are these. I do not consent to searches. That is it. 5 words. Say them calmly. Say them without hostility. Say them once, clearly. You do not need to explain yourself. You do not need to argue the law. You do not need to get into a roadside debate about Barnes versus Felix. Those 5 words create a legal record that now carries more weight than ever before, because under the totality of the circumstances review, a court will see that you asserted your rights while remaining calm and cooperative throughout the rest of the interaction. That combination, clear refusal of consent plus documented calm behavior, is precisely the kind of full timeline record this ruling was designed to protect. Now here's the hard reality that you also need to hear. If an officer decides to search your vehicle despite your refusal, you do not argue constitutional law with someone wearing a badge on the side of a dark road. You do not physically resist. You do not escalate. That is not cowardice, and that is strategy, because the side of the road is not where this battle gets won. The courtroom is where it gets won, and right now, thanks to this ruling, the courtroom has never been more favorable to your side of the argument. If a search proceeds after you have clearly stated that you do not consent, your job becomes documentation. Say clearly, Officer, I am complying with your instructions, but I am doing so under protest and I do not consent to this search. Then mentally record everything you can. How long was the stop before the search began? What specific reason did the officer give for searching? Did they mention your firearm as the justification? What was your behavior throughout the entire stop? If you have a dash cam, and after this ruling you absolutely should, that footage is now one of the most powerful legal tools available to you, because the totality of the circumstances standard means a court will review the entire interaction on that recording. If you were calm and cooperative for 7 minutes and the officer's stated justification was nothing more than the presence of your legal firearm, that recording becomes the foundation of a suppression argument that this ruling just made significantly stronger. The moment the stop is over and you are safely away from the scene, document everything in as much detail as possible. Do it immediately before memory starts degrading. Time of the stop, location, officer's name and badge number if you were able to get it, the exact words used to justify the search, what was searched and in what order. Every detail matters because legal challenges are built on specifics and memory is not reliable after 24 hours. Then contact a civil rights attorney, not in a few days, not after you see how the situation develops, immediately. Because with the Barnes ruling now on the books, attorneys who handle these cases have a legal foundation they did not have before. If a search was conducted based primarily on your lawful possession of a firearm, the suppression argument is now significantly stronger than it has ever been. Evidence obtained through an illegal search gets thrown out. Cases built on illegal searches fall apart. Let me walk you through a real-world scenario so you can see exactly how this plays out. Imagine you are coming back from a day at the shooting range. You have 2 legally owned pistols in a locked case on your back seat. You get pulled over for a dim headlight. The officer approaches, sees the range bag, and asks if there are firearms in the vehicle. You confirm there are. You have your concealed carry permit. You present it calmly. Under the old moment of threat framework, that disclosure could have been treated as the starting gun for a full vehicle search justified by officer safety. The court would look at the moment the officer saw the bag, assess that moment in isolation, and potentially uphold whatever followed. Under Barnes, that framework is gone. The court now has to look at the totality. You were cooperative from the first second. You disclosed voluntarily and calmly. You presented legal documentation. The underlying violation was a dim headlight. There is no criminal activity. There are no specific articulable facts pointing to any threat. If that officer searches your vehicle under those circumstances, they are now acting in direct conflict with a unanimous Supreme Court mandate. And if you refuse consent, stated your objection clearly, and documented the interaction, your attorney has everything they need. Now here's the part of this ruling that goes far beyond your car, and this is what almost no one is talking about yet. The principle at the core of the Barnes decision, stated as plainly as possible, is this. Exercising one constitutional right cannot be used as justification to violate another constitutional right. Read that again. Because that principle does not live only in your vehicle. It lives everywhere constitutional rights apply. And that is everywhere. Think about what this means for your home. If police cannot use your legal right to carry a firearm in your car as the primary justification for a warrantless vehicle search, the same logic applies to your residence. Your legal ownership of firearms inside your home is not, by itself, probable cause for a search of that home. The Fourth Amendment's protections are actually stronger for your home than for your vehicle. This ruling reinforces and extends the constitutional wall between exercising your rights and forfeiting your privacy. Legal gun ownership is not a red flag. It is not a basis for suspicion. It is a constitutionally protected activity that cannot be weaponized against the very people exercising it. Think about what this means for pedestrian stops. If nervousness combined with a legally carried firearm is not enough to justify a full vehicle search under the totality of the circumstances review, how does that translate to stop and frisk situations on foot? That question is going to be litigated aggressively in lower courts over the coming months and years. And the answer, consistent with the Barnes ruling's core principle, should strongly favor the individual. We are already seeing the early stages of this in cases like Case v. Montana in 2026, where courts are being forced to define exactly how reasonable an officer must be when they suspect a weapon is present. Think about what this means for future cases involving digital privacy, firearm purchase records, and law enforcement access to information about gun owners. The framework this ruling establishes, that one constitutional right cannot be used to erode another, is a tool that civil liberties attorneys are already preparing to deploy in new contexts. This 9-0 decision is not just a ruling. It is a legal instrument. It is a foundation stone for a new era in which the Second and Fourth Amendments function as a unified shield rather than competing interests. And here is why the unanimity of this ruling is so significant beyond what most people understand. When 5 justices agree on something, the other 4 write dissents. They explain their disagreements. They plant seeds for future challenges. They create ambiguity. They leave doors open for future courts to limit or reverse what was decided. When 9 justices agree, when there are 0 dissents, there is no ambiguity. There are no seeds of future reversal. There are no doors left open. The message sent to every law enforcement agency, every lower court, every judge, every prosecutor in the country is unambiguous and unanimous. Stop treating the lawful exercise of constitutional rights as grounds for suspicion. Stop using legal gun ownership as a backdoor to circumvent Fourth Amendment protections. Stop putting on the chronological blinders. This is the law. There is no other interpretation. And when a ruling is 5-4, a single retirement from the court can eventually shift the legal landscape. When it is 9-0, it stays the law of the land for generations. Political shifts in the court's composition do not change it. Future nominations do not threaten it. The legal ground beneath this ruling is as solid as it has ever been for any decision in recent memory. But here is something critical that you need to hold in your mind alongside everything else. The Supreme Court does not ride along in your passenger seat. This ruling is a massive victory on paper. It is settled law. It is unanimous and ironclad. But it takes time for landmark decisions to filter down through training programs, department policies, and individual officer behavior. You may encounter officers who are operating under old habits that predate this ruling. You may encounter officers who have not yet been trained on its implications. You may find yourself in a situation where someone in a position of authority acts in direct conflict with what 9 justices unanimously decided. When that happens, the side of the road is still not the place to argue. Your safety matters more than winning that argument in the moment. Comply under protest if you must. State your objection clearly and calmly for the record. Then let the legal process do the rest. Because with this ruling now in place, that process works more powerfully in your favor than it ever has before. The system is now structured to correct what happens on that roadside, but only if you know how to document it, how to preserve it, and how to bring it to the right attorney. So let's lock in the practical framework you walk away with right now. Before you ever get pulled over again, know your state's notification laws cold. Not vaguely, not roughly. Know exactly whether you are required to inform an officer that you are carrying, know exactly when that notification must happen, and know the precise language your state expects. This ruling does not change those state-level requirements. What it changes is everything that happens after you comply with them. Keep your hands visible from the moment you pull over. Before you reach for your license or registration, tell the officer what you are about to do. Announce your movements. This is basic practice that diffuses tension before it has a chance to build. Under the totality of the circumstances review, your composed, transparent behavior from the first second of the stop is now part of the legal record that protects you. If an officer asks to search your vehicle, the answer is 5 words. I do not consent to searches. Say it once. Say it calmly. Then stop talking about it. You are not being difficult. You are exercising a constitutional right that the Supreme Court just unanimously affirmed. If the officer has actual specific articulable probable cause, they will proceed. If they do not, your refusal is now on record, and that record matters enormously under the totality of the circumstances standard. If a search happens despite your refusal, state clearly that you are complying under protest and that you do not consent. Then shift into documentation mode. Everything you can observe and remember goes into your mental record. Get to a safe location and immediately write down or voice record every detail while it is fresh. Then call an attorney before you do anything else. Your dash cam is now one of the most important tools you own. In the post-Barnes world, video that captures the full timeline of a traffic stop interaction is not just convenient. It is the documentary evidence that the court's lengthier time frame standard was built to evaluate. A recording showing 5 minutes of calm, cooperative, law-abiding behavior before any moment of tension is exactly the kind of totality of the circumstances evidence that dismantles a pretextual search in court. Here's the bottom line that this entire ruling comes down to. Barnes v. Felix, decided 9-0 by the Supreme Court, eliminated the moment of threat doctrine. Courts must now evaluate police conduct across the full timeline of an interaction, not just the final 2 seconds. Your legal firearm is not a magic wand that officers can wave to make your Fourth Amendment rights disappear. It is not probable cause. It is not reasonable suspicion. It is not articulable evidence of criminal intent. It is a constitutionally protected possession, and its presence in your vehicle cannot be isolated from the full context of your cooperative, law-abiding behavior to manufacture a justification for a warrantless search. Your Second Amendment rights and your Fourth Amendment rights are not in competition with each other. They do not cancel each other out. They coexist. They protect each other, and the highest court in the country just confirmed that with a unanimous voice that carries more legal weight than almost any ruling in recent history. Know your state notification laws. Stay calm from the first second of every stop. Use those 5 words when asked for consent. Document everything if your rights are violated. And get to an attorney immediately, because this ruling just gave that attorney more powerful ammunition than they have ever had before. That is what changed. That is why it matters. And that is why you needed to hear it explained in plain language instead of buried in 50 pages of legal opinion that most people will never read. The law is on your side right now in a way it has never been before. But it only protects you if you know it exists. This ruling is already rippling through courtrooms, civil rights lawsuits, and police department training programs across the country. The full impact of what just happened is only beginning to unfold. Attorneys are already preparing arguments built on this foundation. Lower courts are being forced to reckon with what 9 unanimous justices handed down. And the gun owners who know about this ruling, who understand what it means and how to invoke it, are the ones who will benefit when it matters most. Do not be the person who learns about this ruling for the first time in the back of a police car. Stay informed, stay documented, stay legal.